Okay, so magandang gabi sa inyo at dito na naman ang inyong Lolo Ray para sa isa na namang edisyon ng pagbabasa natin ng mga batas, no? At subukan natin itong ipaliwanag in layman's term, no? Pero mahirap ipaliwanag kaya hindi ko alam kung nagtatagumpay ba ako. It's more of just reading, no? Babasa lang tayo. Anyway, first time kong magkaroon ng Michael Jordan. Okay, 23. First time ko magkaroon ng Michael Jordan jersey. Okay, si Michael Jordan po ay ang aking favorite player of all time, no? At nagpapasalamat ako, regalo yan ng aking brother, ng aking kuya. So maraming salamat sa iyo, Kuya Mimoy, sa aking Michael Jordan jersey. At pasensya na kayo na baliktad ang aking t-shirt kasi nagtrabaho ako kanina doon sa taniman. Naglinis ako, nagdilig, at saka nagtabas. So binabaliktad ko minsan yung isang t-shirt na gamit na para hindi naman masyadong madumihan yung labas. Kung mamantsahan man, ano. Anyway, nasa mercantile law pa rin tayo o commercial law. Binabasa pa rin natin ang Intellectual Property Code. So, nandito na tayo sa part 3. The Law on Trademarks, Service Marks, and Trade Names. Okay. Magsisimula ang part 3 sa section 121. Mag-define muna tayo ng mga terms, okay? Ibig sabihin daw ng mark means any visible sign capable of distinguishing the goods o yung trademark or services, service mark of an enterprise and shall include a stamped or marked container of goods. Collective mark means any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristic, including the quality of goods or services of different enterprises which use the sign under the control of the registered owner of the collective mark. Trade name means the name or designation identifying or distinguishing an enterprise. Okay, bureau means the Bureau of Trademarks. Director means the Director of Trademarks. Regulations means the rules of practice in trademarks and service marks formulated by the Director of Trademarks and approved by the Director General. Examiner means the trademark examiner. Ayun, yun yung mga terms na dinefine natin. No? Section 122, how marks are acquired. The rights in a mark shall be acquired through registration made validly in accordance with the provisions of this law. So, paano naman yung registration, registrability? Sabi rito, a mark cannot be registered if, letter A, it consists of immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. Ito yung mga hindi mo pwedeng mga hindi pwedeng irehistro ng mga marks. Letter B consists of the flag or coat of arms or other insignia of the Philippines or any of its political subdivisions or of any foreign nation or any simulation thereof. Letter C consists of a name, portrait, or signature identifying a particular living individual, except by his written consent, or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow, if any, except by written consent of the widow. Letter D, kapag yung mark is identical with a registered mark belonging to a different proprietor, or a mark with an earlier filing or priority date in respect of the same goods or services or closely related goods or services, or if it nearly resembles such a mark as to be likely to deceive or cause confusion. Kunwari, Jolly Boy, Jollibee, gumawa ako Jolly Boy tapos babuyog din siya. Letter E is identical with or confusingly similar to or constitutes a translation of a mark which is considered by the competent authority of the Philippines to be well known internationally and in the Philippines, whether or not it is registered here as being already the mark of a person other than the applicant for registration and used for identical or similar goods or services. Provided that in determining whether a mark is well known, account shall be taken of the knowledge of the relevant sector of the public rather than of the public at large, including knowledge in the Philippines which has been obtained as a result of the promotion of the mark. Letter F, napakarami nito, mga marks na hindi mo pwedeng i-register. Kapag yung mark is identical with or confusingly similar to or constitutes a translation of a mark considered well known in accordance with the preceding paragraph, which is registered in the Philippines with respect to goods or services which are not similar to those with respect to which registration is applied for. Provided that use of the mark in relation to those goods or services would indicate a connection between those goods or services and the owner of the registered mark. Provided further that the interests of the owner of the registered mark are likely to be damaged by such use. Letter G is likely to mislead the public, particularly as to the nature, quality, characteristics, or geographical origin of the goods or services. Letter H consists exclusively of signs that are generic for the goods or services that they seek to identify. Masyadong generic, masyadong hindi naman sila madidistinguish dun sa pinaparegister nila na sign. Letter I consists exclusively of signs or of indications that have become customary or usual to designate the goods or services in everyday language or in a bona fide and established trade practice. Letter J consists exclusively of signs or of indications that may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, time or production of the goods, or rendering of the services, or other characteristics of the goods or services. Letter K consists of shapes that may be necessitated by technical factors or by the nature of the goods themselves or factors that affect their intrinsic value. Letter M is contrary to public order or morality. Okay, yun lahat yung mga hindi registrable marks, ano. Subsection 123.2. Sabi niya, as regards signs or devices mentioned in paragraphs J, K, L, nothing shall prevent the registration of any such sign or device which has become distinctive in relation to the goods for which registration is requested as a result of the use that have been made of it in commerce in the Philippines. The office may accept as prima facie evidence that the mark has become distinctive as used in connection with the applicant's goods or services in commerce, proof of substantially exclusive and continuous use thereof by the applicant in commerce in the Philippines for 5 years before the date on which the claim of distinctiveness is made. Subsection 123.3. The nature of goods to which the mark is applied will not constitute an obstacle to registration. Ito, mahaba na naman yung section 124 kasi nakapaloob dito yung requirements for application. Okay? The application for registration of the mark shall be in Filipino or in English and shall contain the following. Letter A, request for registration. Letter B, the name and address of the applicant. Letter C, the name of a state of which the applicant is a national or where he has domicile, and the name of a state in which the applicant has a real and effective industrial or commercial establishment, if any. Letter D, where the applicant is a juridical entity the law under which it is organized and existing. Letter E, the appointment of an agent or representative if the applicant is not domiciled in the Philippines. Letter F, where the applicant claims the priority of an earlier application, an indication of. Letter I, the name of the state with whose national office the earlier application was filed, or it filed with an office other than the national office, the name of that office. Uh, okay. Sandali, ibalangkas natin, oh. Doon sa letter F, sabi niya, where the applicant claims the priority of an earlier application, an indication of the name of the state whose national office the earlier application was filed, or it filed with an office other than a national office, the name of that office, the date on which the earlier application was filed, and where available the application number of the earlier application. So, letter F yun buo. Letter G, where the applicant claims color as a distinctive feature of the mark, o kung color yung distinctive feature ng mark mo. A statement to that effect, as well as the name or names of the color or colors claimed, and an indication in respect of each color of the principal parts of the mark which are in that color. Letter H, where the mark is a three-dimensional mark, a statement to that effect. Letter I, one or more reproductions of the mark as prescribed in the regulations. Letter J, a transliteration or translation of the mark or of some parts of the mark as prescribed in the regulations. Letter K, the names of the goods or services for which the registration is sought, grouped according to the classes of the NICE classification, together with the number of the class of the said classification to which each group of goods or services belongs. And letter L, a signature by or other self-identification of the applicant or his representative. Ang daming kailangan, no? Para sa registration of the mark. Diba? Magtungo tayo sa subsection 124.2. The applicant or the registrant shall file a declaration of actual use of the mark with evidence to that effect as prescribed by the regulations within 3 years from the filing date of the application. Otherwise, the application shall be refused or the mark shall be moved from the register by the director. Subsection 124.3. One application may relate to several goods and or services whether they belong to one class or to several classes of the NICE classification. And subsection 124.4, sinasabi niya rito, if during the examination of the application, the office finds factual basis to reasonably doubt the veracity of any indication or element in the application, it may require the applicant to submit sufficient evidence to remove the doubt. Okay? Punta na tayo sa section 125. Representation at saka yung address for service. If the applicant is not domiciled or has no real and effective commercial establishment in the Philippines, he shall designate by a written document filed in the office the name and address of a Philippine resident who may be served notices or proceedings or process in proceedings affecting the mark. Okay, such notices or services may be served upon the person so designated by leaving a copy thereof at the address specified in the last designation filed. If the person so designated cannot be found at the address given in the last designation, such notice or process may be served upon the director. Similar din to dun sa binasa natin about foreign corporations, no? Sa foreign corporations na nag-a-apply dito ng authority to transact business, kailangan meron silang representative na resident ng Pilipinas, kung saan doon mo isi-serve yung mga summons na related sa pakikipag-transact ng korporasyon na yun dito. Similar din yon doon sa isang tao na hindi nakatira dito sa Pilipinas at wala naman siyang commercial establishment dito sa Pilipinas, tapos nag-a-apply siya, di ba? Okay. Section 126, disclaimers. The office may allow or require the applicant to disclaim an unregistrable component of an otherwise registrable mark, but such disclaimer shall not prejudice or affect the applicant's or owner's rights then existing or thereafter arising in the disclaimed matter, nor such shall disclaimer prejudice or affect the applicant's or owner's right on another application of later date if the disclaimed matter became distinctive of the applicant's or owner's goods, business, or services. Tungo naman tayo sa Section 127 ng Intellectual Property Code pa rin, yung filing date. Okay? Requirements. The filing date of an application shall be the date on which the office received the following indications and elements in English or Filipino. Letter A, an express or implicit indication that the registration of a mark is sought. Okay? Nag-a-apply ka na marehistro ang iyong mark. Letter B, the identity of the applicant. Letter C, indications sufficient to contact the applicant or his representative, if any. Letter D, a reproduction of the mark whose registration is sought. And letter E, the list of the goods or services for which the registration is sought. Sabi rito, no filing date shall be accorded until the required fee is paid. Okay, so yun ang requirements. Okay. Laging may filing fee, parang korte rin, ano? Income generating agency. Section 128, single registration for goods and or services. Where goods and or services belonging to several classes of the nice classification have been included in one application, such an application shall result in one registration. Section 129, division of application. Any application referring to several goods or services, hereafter referred to as the initial application, may be divided by the applicant into two or more applications, hereafter referred to as the divisional applications, by distributing among the latter goods or services referred to in the initial application. The divisional applications shall preserve the filing date of the initial application or the benefit of the right of priority. Section 130, signature and other means of self-identification. Where signature is required, the office shall accept letter A, a handwritten signature, or letter B, the use of other forms of signature such as printed or stamped signature or the use of a seal instead of a handwritten signature. Provided that where a seal is used, it should be accompanied by an indication in letters of the name of the signatory. The office shall accept communications to it by telecopier or by electronic means, subject to the conditions or requirements that will be prescribed by the regulations. When communications are made by telefacsimile, the reproduction of the signature or the reproduction of the seal, together with, where required, the indication in letters of the name of the natural person whose seal is used, appears. The original communications must be received by the office within 30 days from the date of receipt of the telefacsimile. Baka sa mga in the future may mga makabasa nito, baka hindi na nila alam 'yon. Baka makabago na yung lahat. Modern communication na sa inyo, no? No attestation, notarization, authentication, legalization, or other certification of any signature or other means of self-identification referred to in the preceding paragraphs will be required, except where the signature concerns the surrender of a registration. Section 131, priority right. Okay. An application for registration of a mark filed in the Philippines by a person referred to in Section 3 and who previously duly filed an application for registration of the same mark in one of those countries shall be considered as filed as of the day the application was first filed in the foreign country. No registration of a mark in the Philippines by a person described in this section shall be granted until such mark has been registered in the country of origin of the applicant. Nothing in this section shall entitle the owner of a registration granted under this section to sue for acts committed prior to the date on which his mark was registered in this country, provided that notwithstanding the foregoing, the owner of a well-known mark as defined in section 1231E of this act that is not registered in the Philippines may, against an identical or confusingly similar mark, oppose its registration or petition the cancellation of its registration or sue for unfair competition without prejudice to availing himself of other remedies provided for under the law. Okay. In like manner, the subject of the same conditions and requirements, the right provided in this section may be based upon a subsequent regularly filed application in the same foreign country, provided that any foreign application filed prior to such subsequent application has been withdrawn, abandoned, or otherwise disposed of without having been laid open to public inspection and without leaving any rights outstanding and has not served nor thereafter shall serve as a basis for claiming a right of priority. Section 132, application number and filing date. Okay? Napakarami, no? Napakarami requirements para sa pag-apply. The office shall examine whether the application satisfies the requirements for the grant of a filing date as provided in Section 127 and regulations relating thereto. If the application does not satisfy the filing requirements, the office shall notify the applicant who shall, within a period fixed by the regulations, complete or correct the application as required. Otherwise, the application shall be considered withdrawn. Once an application meets the filing requirements of Section 127, it shall be numbered in the sequential order and the applicant shall be informed of the application number and the filing date of the application will be deemed to have been abandoned. Section 133, examination and publication. Okay, ang daming requirements. May requirements pa na examination and publication. Once the application meets the filing requirements of Section 127, the office shall examine whether the application meets the requirements of Section 124 and the mark as defined in Section 121 is registrable under Section 123. Where the office finds that the conditions referred to in subsection 133.1 are fulfilled, it shall, upon payment of the prescribed fee, forthwith cause the application as filed to be published in the prescribed manner. If after the examination the applicant is not entitled to registration for any reasons, the office shall advise the applicant thereof and the reasons therefore. The applicant shall have a period of 4 months in which to reply or amend his application, which shall then be re-examined. The regulations shall determine the procedure for the re-examination or revival of an application as well as the appeal to the Director of Trademarks from any final action by the examiner. An abandoned application may be revived as a pending application within 3 months from the date of abandonment upon good cause shown and the payment of the required fee. The final decision of refusal of the Director of Trademarks shall be appealable to the Director General in accordance with the procedure fixed by the regulations. Section 134, opposition. Any person who believes that he would be damaged by the registration of a mark may, upon payment of the required fee and within 30 days after the publication referred to in subsection 133.2, file with the office an opposition to the application. Such opposition shall be in writing and verified by the oppositor or by any grounds on his behalf who knows the facts and shall specify the grounds on which it is based and include a statement of facts relied upon. Copies of certificates of registration of marks registered in other countries or other supporting documents mentioned in the opposition shall be filed therewith together with the translation in English, if not in the English language. For good cause shown and upon payment of the required surcharge, the time for filing an opposition may be extended by the Director of Legal Affairs, who shall notify the applicant of such extension. The regulation shall fix the maximum period of time within which to file the opposition. Okay, yun yung provision nitong batas na ito kapag merong tao na inaakala niya madadamage siya nung isang hinihiling na registration ng isang mark. Okay. Section 135, Notice and Hearing. Upon the filing of an opposition, the office shall serve notice of the filing on the applicant and of the date of the hearing thereof upon the applicant and the oppositor and all other person having any right, title, or interest in the mark covered by the application as appear of record in the office. Section 136, Issuance and Publication of Certificate. When the period for filing the opposition has expired, or when the Director of Legal Affairs shall have denied the opposition, the office, upon payment of the required fee, shall issue the certificate of registration. Upon issuance of a certificate of registration, notice thereof making reference to the publication of the application shall be published in the IPO Gazette. Okay, Section 137, Registration of mark and issuance of a certificate to the owner or his assignee. The office shall maintain a register in which shall be registered marks, numbered in the order of their registration, and all transactions in respect of each mark required to be recorded by virtue of this law. The registration of a mark shall include a reproduction of the mark and shall mention its number, the name and address of the registered owner, and if the registered owner's address is outside the country, his address for service within the country, the dates of application and registration, if priority is claimed, an indication of this fact, and the number, date, and country of the application, basis of the priority claims, the list of goods or services in respect of which registration has been granted, with the indication of the corresponding class or classes, and such other data as the regulations may prescribe from time to time. A certificate of registration of a mark may be issued to the assignee of the applicant, provided that the assignment is recorded in the office. In case of a change of ownership, the office shall, at the written request signed by the owner or his representative, or by the owner or his representative, and upon a proper showing and the payment of the prescribed fee, issue to such assignee a new certificate of registration to the said mark in the name of such assignee and for the unexpired part of the original period. If the office shall record any change of address or address for service, which shall be notified to it by the registered owner. In the absence of any provision to the contrary in this act, communications to be made to the registered owner by virtue of this act shall be sent to him at his last recorded address and at the same time at his last recorded address for service. So, in fairness, lagi ako nagre-reklamo sa mga filing fee. Di ba? Magko-contest ka, magbabayad ka, i-contest mo yung registration, magbabayad ka. Pero, ito kasing batas na to, inoorganisa niya yung mga naka-register sa IPO office, sa Intellectual Property Office. So, yung pag-oorganisa pa lamang, yung pagbabalangkas pa lamang, yung pag-iisa-isa, yung pagsusunod-sunod, tapos syempre yung requirement of publishing, talagang kakailangan nila ng pondo, kaya ang daming fee rin na nire-require sa isang nagpaparegister ng kanyang trade name o ano pa man, di ba? Section 138, Certificates of Registration. A certificate of registration of a mark shall be prima facie evidence of the validity of the registration, the registrant's ownership of the mark, and of the registrant's exclusive right to use the same in connection with the goods or services and those that are related thereto specified in the certificate. Okay, Section 139, Publication of Registered Marks, Inspection of Register. The office shall publish in the form and within the period fixed by the regulations the mark registered in the order of their registration, reproducing all the particulars referred to in subsection 137.2. Marks registered at the office may be inspected free of charge, and any person may obtain copies thereof at his own expense. This provision shall also be applicable to transactions recorded in respect of any registered mark. Section 140. Cancellation upon application by registrant, amendment or disclaimer of registration. Upon application of the registrant, the office may permit any registration to be surrendered for cancellation, and upon cancellation, the appropriate entry shall be made in the records of the office. Upon application of the registrant and payment of the prescribed fee, the office for good cause may permit any registration to be amended or to be disclaimed in part, provided that the amendment or disclaimer does not alter materially the character of the mark. Appropriate entry shall be made in the records of the office upon the certificate of registration, or if said certificate is lost or destroyed, upon a certified copy thereof. Section 41, Sealed and certified copies as evidence. Copies of any records, books, papers, or drawings belonging to the office relating to marks, and copies of registrations, when authenticated by the seal of the office and certified by the Director of the Administrative, Financial, and Human Resource Development Service Bureau, or in his name by an employee of the office duly authorized by said Director, shall be evidence in all cases wherein the originals would be evidence. And any person who applies and pays the prescribed fee shall secure such copies. Section 142, Correction of mistakes made by the office. Whenever a material mistake in a registration incurred through the fault of the office is clearly disclosed by the records of the office, a certificate stating the fact and nature of such mistake shall be issued without charge. Recorded and printed copy thereof shall be attached to each printed copy of the registration. Such corrected registration shall thereafter have the same effect as the original certificate, or in the discretion of the Director of the Administrative, Financial, and Human Resource Development Service Bureau, a new certificate of registration may be issued without charge. All certificates of correction heretofore issued in accordance with the regulations and the registration to which they are attached shall have the same force and effect as if such certificates and their issuance had been authorized by this Act. Section 143, Correction of mistakes made by applicant. Whenever a mistake is made in a registration and such mistake occurred in good faith through the fault of the applicant, the office may issue a certificate upon the payment of the prescribed fee, provided that the correction does not involve any change in the registration that requires republication of the mark. Section 144, Classification of Goods and Services. Each registration and any publication of the office which concerns an application or registration effected by the office shall indicate the goods or services by their names, grouped according to the classes of the NICE classification, and each group shall be preceded by the number of the class of that classification to which that group of goods or services belongs, presented in the order of the classes of the said classification. Goods or services may not be considered as being similar or dissimilar to each other on the ground that, In any registration or publication by the office, they appear in different classes of the NICE classification. Section 145. Duration. Ayan. A certificate of registration shall remain in force. Sandali lamang. Okay, a certificate of registration shall remain in force for 10 years provided that the registrant shall file a declaration of actual use and evidence to that effect, or shall show valid reasons based on the existence of obstacles to such use as prescribed by the regulations within 1 year from the 5th anniversary of the date of the registration of the mark. Otherwise, the mark shall be removed from the register by the office. Okay, yun ang section 145. Punta naman tayo sa section 146, yung renewal. A certificate of registration may be renewed for periods up to 10 years at its expiration upon payment of the prescribed fee and upon filing fee of a request. The request shall contain the following indications. Okay, so kung ikaw pala ay naka-obtain ng certificate of registration, renewable siya for periods of 10 years, no? So the request shall contain the following indications. Letter A, an indication that renewal is sought. Letter B, the name and address of the registrant or his successor in interest, hereafter referred as the right holder. Letter C, the registration number of the registration concerned. Letter D, the filing date of the application which resulted in the registration concerned to be renewed. Letter E, where the right holder has a representative, the name and address of that representative. Letter F, the names of the recorded goods or services for which the renewal is requested, or the names of the recorded goods or services for which the renewal is not requested, grouped according to the class of the NICE classification to which that group of goods or services belongs, and presented in the order of the classes of the said classification. And letter G, a signature by the right holder or his representative. Okay. Sa section 146 pa rin to, pero subsection 2 na. Such request shall be in Filipino or English and may be made at any time within 6 months before the expiration of the period for which registration was issued or renewed, or it may be within 6 months after such expiration and payment of the additional fee herein prescribed. If the office refuses to renew the registration, it shall notify the registrant of his refusal and the reasons therefor. An applicant for renewal not domiciled in the Philippines shall be subject to and comply with the requirements of this act. Section 147, Rights Conferred. Sabi rito, the owner of a registered mark shall have the exclusive right to prevent all third parties not having the owner's consent from using in the course of trade identical or similar signs or containers for goods or services which are identical or similar to those in respect of which the trademark is registered, where such use would result in a likelihood of confusion. In case of the use of an identical sign for identical goods or services, a likelihood of confusion shall be presumed. The exclusive right of the owner of a well-known mark defined in subsection 123.1, letter E, which is registered in the Philippines, shall extend to goods and services which are not similar to those in respect of which the mark is registered, provided that use of that mark in relation to those goods or services would indicate a connection between those goods or services and the owner of the registered mark. Provided further that the interests of the owner of the registered mark are likely to be damaged by such use. Section 148, use of indications by third parties for purposes other than those for which the mark is used. Registration of the mark shall not confer on the registered owner the right to preclude third parties from using bona fide their names, addresses, pseudonyms, a geographical name, or exact indications concerning the kind, quality, quantity, destination, value, place of origin, or time of production or of supply of their goods or services, provided that such use is confined to the purposes of mere identification or information and cannot mislead the public as to the source of the goods or services. Yun naman ang mahalaga yung you will not mislead the public, no? Section 149, assignment and transfer of application and registration. An application for registration of a mark or its registration may be assigned or transferred with or without the transfer of the business using the mark. Such assignment or transfer shall, however, be null and void if it is liable to mislead the public, particularly as regards the nature, source, manufacturing process, characteristics, or suitability for their purpose of the goods or services to which the mark is applied. The assignment of the application for registration of a mark or of its registration shall be in writing and require the signatures of the contracting parties. Transfers by mergers or other forms of succession may be made by any document supporting such transfer. Assignments and transfers of registration of marks shall be recorded at the office on payment of the prescribed fee. Assignment and transfers of applications for registration shall, on payment of the same fee, be provisionally recorded, and the mark, when registered, shall be in the name of the assignee or transferee. Assignments and transfers shall have no effect against third parties until they are recorded at the office. Okay. Section 150, license contracts. Any license contract concerning the registration of a mark or an application therefore shall provide for effective control by the licensor of the quality of the goods or services of the licensee in connection with which the mark is used. If the license contract does not provide for such quality control, or if such quality control is not effectively carried out, the license contract shall not be valid. Kailangan itong license contract na to shall provide for effective control by the licensor. Okay. Doon sa licensee. Kung hindi lang din ganun ang resulta, the license contract shall not be valid. A license contract shall be submitted to the office, which shall keep its contents confidential, but shall record it and publish a reference thereto. A license contract shall have no effect against third parties until such recording is effected. The regulations shall fix the procedure for the recording of the license contract. Okay, Section 151, cancellation. Ayan. A petition to cancel a registration of a mark under this act may be filed with the Bureau of Legal Affairs. Okay? Doon may pa-file. Di ba nabanggit na natin ang Intellectual Property Office ay nahati sa iba't ibang mga bureau at isa na doon ay ang Bureau of Legal Affairs. So pwede raw mag-file ng petition to cancel a registration mark by any person who believes that he is or will be damaged by the registration of a mark under this act as follows. Letter A, within 5 years from the date of the registration of the mark under this act. Malinaw yun, within 5 years. Letter B, at any time if the registered mark becomes the generic name for the goods or services or a portion thereof for which it is registered or has been abandoned or its registration was obtained fraudulently or contrary to the provisions of this act, or if the registered mark is being used by or with the permission of the registrant so as to misrepresent the source of the goods or services on or in connection with which the mark is used. If the registered mark becomes the generic name for less than all of the goods or services for which it is registered, a petition to cancel the registration may only registration for only those goods or services may be filed. A registration mark shall not be deemed to be the generic name of the goods or services solely because such mark is also used as a name of or to identify a unique product or service. The primary significance of the registered mark to the relevant public rather than the purchaser motivation shall be the test for determining whether the registered mark has become the generic name of goods or services on or in connection with which it has been used. So, ang sabi rito ha, the primary significance of the registered mark, okay, to the relevant public rather than purchaser motivation shall be the test. Yun ang magiging test para malaman whether the registered mark has become the generic name of goods or services o hindi pa. And letter C, at any time, if the registered owner of the mark without legitimate reason fails to use the mark within the Philippines or to cause it to be used in the Philippines by virtue of a license during an uninterrupted period of 3 years or longer. Okay. Doon daw pwedeng magpetisyon para sa cancellation. Okay. Okay, Article 151, subsection 2, notwithstanding, sabi niya, the foregoing provisions, the court or the administrative agency vested with jurisdiction to hear and adjudicate any action to enforce the rights to a registered mark shall likewise exercise jurisdiction to determine whether the registration of said mark may be cancelled in accordance with this act. The filing of a suit to enforce the registered mark with the proper court or agency shall exclude any other court or agency from assuming jurisdiction over a subsequently filed subsequently filed petition to cancel the mark. So kapag ka meron ng isang korte or administrative body na nag-assume ng jurisdiction, sabi ng batas na ito, okay, it shall exclude any other court, sabi, or agency from assuming jurisdiction. On the other hand, the earlier filing of petition to cancel the mark with the Bureau of Legal Affairs shall not constitute a prejudicial question that must be resolved before an action to enforce the rights to same registered mark may be decided. So sabi rito, the earlier filing ng petition to cancel the mark sa Bureau of Legal Affairs ng Intellectual Property Office shall not constitute a prejudicial question. Diba, ibig sabihin ng prejudicial question kailangan mo nang i-resolba, okay, bago magtuloy yung kaso. Hindi raw ganon. It shall not, yung filing of petition to cancel the mark sa Bureau of Legal Affairs shall not constitute a prejudicial question. Ibig sabihin, pwedeng magtuloy ang iyong action to enforce the rights of the registered mark na pwedeng desisyonan. Yun ang ibig sabihin. Okay, section 152. Okay. Non-use of a mark when excused. Non-use of a mark may be excused if caused by circumstances arising independently of the will of the trademark owner. Lack of funds shall not excuse non-use of a mark. The use of a mark in a form different from the form in which it is registered, which does not alter its distinctive character, shall not be a ground for cancellation or removal of the mark, and shall not diminish the protection granted to the mark. The use of a mark in connection with one or more of the goods or services belonging to the class in respect of which the mark is registered shall prevent its cancellation or removal in respect of all other goods or services of the same class. The use of a mark by a copy related with the registrant or applicant shall inure to the latter's benefit, and such use shall not affect the validity of such mark or of its registration, provided that such mark is not used in such manner as to deceive the public. If use of a mark by a person is controlled by the registrant or applicant with respect to the nature and quality of the goods or services, such use shall inure to the benefit of the registrant or applicant. Section 153, Requirements of Petition, Notice, and Hearing. Insofar as applicable, the petition for cancellation shall be in the same form as that provided in Section 134 hereof, and notice and hearing shall be provided in Section 135 hereof. Okay. Section 154, Cancellation of Registration. Sabi rito, if the Bureau of Legal Affairs finds that a case for cancellation has been made out, it shall order the cancellation of the registration. When the order or judgment becomes final, any right conferred by such registration upon the registrant or any person in interest of record shall terminate. Notice of cancellation shall be published in the IPO Gazette. Section 155, Remedies at saka yung infringement. Any person who shall, without the consent of the owner of the registered mark, use, in commerce, any reproduction, counterfeit, copy, or colorable imitation of a registered mark, or the same container, or a dominant feature thereof in connection with the sale, offering for sale, distribution, advertising of any goods or services, including other preparatory steps necessary to carry out the sale of any goods or services on or in connection with which such use is likely to cause confusion or to cause mistake or to deceive naman, or reproduce, counterfeit, copy, or colorably imitate a registered mark or a dominant feature thereof and apply such reproduction, counterfeit, copy, or colorable imitation to labels, signs, prints, packages, wrappers, receptacles, or advertisements intended to be used in commerce upon or in connection with the sale, offering for sale, distribution, or advertising of goods or services on or in connection with which such use is likely to cause confusion or to cause mistake or to deceive shall be liable in a civil action for infringement by the registrant for the remedies hereinafter set forth, provided that the infringement takes place at the moment any of the acts stated in subsection 155.1 or this subsection are committed regardless of whether there is actual sale of goods or services using the infringing material. Okay? So yun, ibig sabihin nun, isa kang any person na ginawa yung mga bagay na nabanggit natin without the consent of the owner of the registered mark shall be liable for infringement, di ba? Section 156, Actions and Damages and Injunction for Infringement. Napag-usapan na natin yan, di ba? Yung last time na similarly, meron tayong binasa dun sa previous na binasa natin about intellectual property wherein pwede kang mag-file sa korte ng action for preliminary ng petition for preliminary injunction at manghingi ka ng civil damages, di ba? The owner of a registered mark may recover damages from any person who infringes his rights, and the measure of the damages suffered shall be either the reasonable profit which the complaining party would have made had the defendant not infringed his rights, or the profit which the defendant actually made out of the infringement, or in the event such measure of damages cannot be readily ascertained with reasonable certainty, then the court may award as damages a reasonable percentage based upon the amount of gross sales of the defendant or the value of the services in connection with which the mark or trade name was used in the infringement of the rights of the complaining party. An application of the complainant, court may impound, pwedeng kunin ng court during the pendency of the action, sales invoices and other documents evidencing sales. In cases where actual intent to mislead the public or to defraud the complainant is shown in the discretion of the court, the damages may be doubled. The complainant, upon proper showing, may also be granted injunction. Okay? pwedeng i-grant ng court yung injunction mo na pinapahinto mo siya sa paggamit, 'di ba, ng iyong intellectual property, 'di ba? Section 157, power of court to order infringing material destroyed. Ayan. In any action arising under this act in which a violation of any right of the owner of the registered mark is established, the court may order that goods found to be infringing be, without compensation of any sort, disposed of outside the channels of commerce in such manner as to provide any harm caused to the right holder or destroyed, and all labels, signs, prints, packages, wrappers, receptacles, and advertisements in the possession of the defendant bearing the registered mark or trade name of or any reproduction, counterfeit copy, or colorable imitation thereof. All plates, molds, matrices, and other means of making the same shall be delivered up and destroyed. Pwedeng i-order ng korte yun. In regard to counterfeit goods, the simple removal of the trademark affixed shall not be sufficient, di yun sapat, other than in exceptional cases, which shall be determined by the regulations to permit the release of the goods into the channels of commerce. Section 158, damages, tsaka yung requirement of notice. In any suit for infringement, the owner of the registered mark shall not be entitled to recover profits or damages unless the acts have been committed with knowledge that such imitation is likely to cause confusion or to cause mistake or to deceive. Such knowledge is presumed if the registrant gives notice that his mark is registered by displaying with the mark the words registered mark or the letter R within a circle, or if the defendant had otherwise actual notice of the registration. So pinakamainam talaga, bago ka magsampa ng kaso, magbigay ka muna ng notice doon sa sasampahan mo ng kaso na, huy, aking yan, ito yung registration ko ng aking mark. So example natin yung Jollibee, yung trademark ng Jollibee, ipakita mo na nakalagay, oh, may registration kami, kakasuhan namin kayo ng damages pag hindi nyo tinigil yan. So, ni-notify mo muna sila pero kung tinuloy pa rin nila, doon na maaaring makakuha ng damages yung complaining party, no? Section 159, limitations to actions for infringement. Notwithstanding any other provisions of this act, the remedies given to the owner of a right infringed under this act shall be limited as follows. Notwithstanding the provisions of Section 155 hereof, a registered mark shall have no effect against any person who, in good faith before the filing date or the priority date, was using the mark for the purposes of his business or enterprise, provided that his right may only be transferred or assigned, together with his enterprise or business, or with that part of his enterprise or business in which the mark is used. Where an infringer, who is engaged solely in the business of printing the mark, or other infringing materials for others, is an innocent infringer, the owner of the right infringed shall be entitled as against such infringer only to an injunction against future printing. So, innocent infringer siya, hindi niya alam, hindi niya sinasadya. Pwede lamang siyang orderan na tumigil, injunction. Where the infringement complained of is contained in or is part of paid advertisement in a newspaper, magazine, or other similar periodical, or in an electronic communication, the remedies of the owner of the right infringed as against the publisher or distributor of such newspaper, magazine, or other similar periodical or electronic communication shall be limited to an injunction against the presentation of such advertising matter in future issues of such newspapers, magazines, or other similar periodicals, or in future transmissions of such electronic communications. The limitations of this subparagraph shall apply only to innocent infringers. Okay, hindi kasama yung nananadya talaga, no? Provided that such injunctive relief shall not be available to the owner of the right infringed with respect to an issue of a newspaper, magazine, or other similar periodical, or an electronic communication containing infringing matter, where restraining the dissemination of such infringing matter in any particular issue of such periodical or in an electronic communication would delay the delivery of such issue or transmission of such electronic communication is customarily conducted in accordance with the sound business practice and not due to any method or device adopted to evade this section or to prevent or delay the issuance of an injunction or restraining order with respect to such infringing matter. Okay, magbabalik tayo para sa section 160. Magpapahinga lamang ako. Diyan lang kayo. Okay, so ako nagbabalik, no? Para basahin pa rin natin ang Intellectual Property Code, no? Basa-basa lang tayo, no? Nakaka-enjoy naman na content ito eh. At least meron tayong mga natututunan, hindi ba? So naririto na tayo sa right of foreign corporation to sue in trademark or service mark at enforcement action. Sabi niya rito, any foreign national or juridical person who meets the requirements of Section 3 of this Act and does not engage in business in the Philippines may bring a civil or administrative action hereunder for opposition, cancellation, infringement, unfair competition, or false designation of origin and false description, whether or not it is licensed to do business in the Philippines under existing laws. Dali lang, ha? Okay, Section 161, authority to determine right to registration. In any action involving a registered mark, the court may determine the right to registration, order the cancellation of a registration in whole or in part, and otherwise rectify the register with respect to the registration of any to the action in the exercise of this. Judgment and orders shall be certified by the court to the director, who shall make appropriate entry upon the records of the Bureau and shall be controlled thereby. Section 162, action for false or fraudulent declaration. Any person who shall procure registration in the office of a mark by a false or fraudulent declaration or representation, whether oral or in writing or by any false means, shall be liable in a civil action by any person injured thereby for any damages sustained in consequence thereof. Section 163, jurisdiction of court. All actions under sections 150, 155, 164, and 166 to 169 shall be brought before the proper courts with appropriate jurisdiction under existing laws. So malinaw yun, ha? Lahat ng mga nakalagay sa section 150, 155, 164, 166, at 169. Yun yung mga action na na pwede mong dalhin sa korte. So hanapin nga natin ulit yun. Ayoko na siyang balikan dyan. Ilagay na lang natin yung section 150, 155, 164, 166, 169. Subukan natin, baka lahat sila mayroong nakalagay dito. Ay, wala nakalagay. Isa-isain mo pa. Okay. O sige, nasa na ba tayo? Nasa 163 naman na tayo eh. So, okay. 163 tayo. So, 150, 155, 164. Okay. 150, balik tayo sa 150. 150 ay yung license contracts, no? Okay, any license contract concerning the registration of a mark or an application therefore shall provide for effective control by the licensor. 155. Okay, yung mga infringement, ito pwedeng ikorte ito. Okay, sabi niya. Yung any person who shall without the consent of the owner of the registered mark. Ayan, gagamitin niya. 164, sabi niya. Dali. At tayo sa 164. Ayan, hindi pa natin nababasa to. Ito. Notice of filing suit given to the director. It shall be the duty of the clerks of such courts within 1 month after the filing of any action suit, or proceeding involving a mark registered under the provisions of this act, to notify the director in writing, setting forth the names and addresses of the litigants and designating the number of the registration or registrations, and within 1 month after the judgment is entered or an appeal is taken, the clerk of court shall give notice thereof to the office, and the latter shall endorse the same upon the file wrapper of the said registration or registrations, and incorporate the same as part of the contents of said file wrapper. So, ito korte kasi ito eh. So, dapat yung clerk of court daw, within 1 month after filing ng any action, suit, or proceeding involving a mark, sabi, shall notify the director ng international intellectual property code, intellectual property office. Yan. Okay, so yun, mamaya pupunta tayo sa 169 kasi may jurisdiction din yung court doon. Pero for now, 165 muna tayo, trade names or business names. A name or designation may not be used as a trade name if by its nature or the use to which such name or designation may be put, it is contrary to public order or morals, and if in particular it is liable to deceive trade circles or the public as to the nature of the enterprise identified by that name. Notwithstanding any laws or regulations providing for any obligation to register trade names, such names shall be protected even prior to or without registration against any unlawful act committed by third parties. In particular, any subsequent use of the trade name by a third party, whether as a trade name or a mark or collective mark, or any such use of a similar trade name or mark likely to mislead the public, shall be deemed unlawful. Okay. The remedies provided for in sections 153 to 156 and sections 166 and 167 shall apply mutatis mutandis. Ibig sabihin, with the same interpretation. 165, in comparison, or shall apply, mutatis mutandis, shall apply in comparison. Parang gano'n yung dating yan. Ibig sabihin yan. Any change in the ownership of a trade name shall be made with a transfer of the enterprise or part thereof identified by that name. The provisions of subsections 149.2 to 149.4 shall apply mutatis mutandis. Okay, section 166, goods bearing infringing marks or trade names. No article of imported merchandise which shall copy or simulate the name of any domestic product or manufacturer or dealer, or which shall copy or simulate a mark registered in accordance with the provisions of this act, or shall bear a mark or trade name calculated to induce the public to believe that the article is manufactured in the Philippines or that it is manufactured in any foreign country or locality other than the country or locality where it is in fact manufactured, shall be admitted to entry at any custom house of the Philippines. In order to aid the officers of the Customs Service in enforcing this prohibition, any person who is entitled to the benefits of this act may require that his name and residence, and the name of the locality in which his goods are manufactured, a copy of the certificate of registration of his mark or trade name, to be recorded in books which shall be kept for this purpose in the Bureau of Customs under such regulations as the Collector of Customs, with the approval of the Secretary of Finance, shall prescribe, and may furnish to the said Bureau facsimiles of his name, the name of the locality in which his goods are manufactured, or his registered mark or trade name, and thereupon the Collector of Customs shall cause one or more copies of the same to be transmitted to each collector or to other proper officer of the Bureau of Customs. 167, collective marks, no? Subject to subsections 167.2 and 167.3, sections 122 to 164 and 166 shall apply to collective marks, except that references therein to mark shall be read as collective mark. An application for registration of a collective mark shall designate the mark as a collective mark and shall be accompanied by a copy of the agreement, if any, governing the use of the collective mark. The registered owner of a collective mark shall notify the director of any changes made in respect of the agreement referred to in paragraph A. In addition to the grounds provided in Section 149, the court shall cancel the registration of a collective mark if the person requesting the cancellation proves that only the registered owner uses the mark, or that he uses or permits its use in contravention of the agreements referred to in subsection 166.2, or that he uses or permits its use in a manner liable to deceive trade circles or the public as to the origin or any other common characteristics of the goods or services concerned. The registration of a collective mark or an application therefore shall not be the subject of a license contract. Okay, yung registration daw ng isang collective mark or an application thereof shall not be the subject of a license contract. Okay, tungo na tayo sa Section 168, Unfair Competition, Rights, Regulation, and Remedies. A person who has identified in the mind of the public the goods he manufactures or deals in, his business or services from those of others, whether or not a registered mark is employed, has a property right in the goodwill of said goods, business, or services so identified, which will be protected in the same manner as other property rights. Nakalagay yan doon sa Civil Code, yung provision niya about property. Any person who shall employ deception or any other means contrary to good faith, by which he shall pass off the goods manufactured by him, or in which he deals, or his business or services, for those of the one having established such goodwill, or who shall commit any acts calculated to produce said result, shall be guilty of unfair competition and shall be subject to an action therefore. In particular, sabi niya, in particular and without in any way limiting the scope of protection against unfair competition, the following, ito mga sasabihin ko, shall be deemed guilty of unfair competition. Letter A, any person who is selling his goods and gives them the general appearance of goods of another manufacturer or dealer, either as to the goods themselves or in the wrapping of the packages in which they are contained, or the devices or words of their own, or in any other feature of their appearance, which would be likely to influence purchasers to believe that the goods offered are those of a manufacturer or dealer other than the actual manufacturer or dealer, or who otherwise clothes the goods with such appearance as shall deceive the public and defraud another of his legitimate trade, or any subsequent vendor of such goods, or any agent of any vendor engaged in selling goods with a like purpose. Okay, guilty yan ng unfair competition. Ha? Letter B, any person who by any article or device or employs any other means calculated to induce the false belief that such person is offering the services of another who has identified such services in the mind of the public. Or letter C, any person who shall make any false statement in the course of trade, or who shall commit any other act contrary to good faith of a nature calculated to discredit the goods, business, or services of another. The remedies provided by sections 156, 157, 161 shall apply in comparison, or shall apply likewise. So, mutatis mutandis, yun nga sinabi nila, no? So, ito, guilty rito sa mga deception, yung mga nagtitinda ng mga peke, fake Louis Vuitton bags, unfair competition yan. Fake Kobe Bryant shoes, mga ganyan. Fake NBA jerseys, ganyan. Sections 169, false designations of origin, false description or representation. Any person who, on or in connection with any goods or services or any container for goods, uses in commerce any word, term, name, symbol, or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact, which, letter A, is likely to cause confusion or to cause mistake or to deceive as to the affiliation, connection, or association of such person with another person, or has to the origin, sponsorship, or approval of his or her goods, services, or commercial activities by another person. Or letter B, in commercial advertising or promotion, misrepresents the nature, characteristics, qualities, or geographic origin of his or her or another person's goods, services, or commercial activities shall be liable to a civil action for damages and injunction provided in sections 156 and 157 of this act by any person who believes that he or she is likely to be damaged by such acts. So punishable sila ang damages under liable sila for civil action for damages. Any goods marked or labeled in contravention of the provisions of this section shall not be imported into the Philippines or admitted entry at any custom house of the Philippines. Yun nga lamang, alam natin hindi ito nangyayari. The owner, importer, or consignee of goods refused entry at any custom house under this section may have any recourse under the customs revenue laws or may have the remedy given by this act in cases involving goods refused entry or seized. Section 170, penalties. Okay. Independent of the civil and administrative sanctions imposed by law, a criminal penalty of imprisonment from 2 years to 5 years and a fine ranging from 50,000 pesos to 200,000 pesos shall be imposed on any person who is found guilty of committing any of the acts mentioned in Section 155, Section 168, and subsection 169.1. So malaki increased criminal imprisonment from 2 years to 5 years and a fine ranging from 500,000 to 200,000 50,000, sorry. Wala palang 500,000. Fine of 50,000 to 200,000 pesos shall be imposed on any person who is found guilty of committing any of the acts dun sa 155, 168, and 155 yung mga cap infringement yan 166. Okay, yung nagkopya ka or simulate a mark registered in accordance with the provisions of this act, may 2 taon kang kulong, 50,000 to 200,000 na 2 to 5 years imprisonment, 50 to 200,000 pesos na penalty, at saka yung 169. Goods marked or labeled in contravention of the provisions of this section. Okay, na in-import mo. Nako. So, wag na tayong, nako. Okay, subukan nating basahin pa rin yung part 4. The law on copyright. Maganda ito. Ito yung pinaka-common sa atin. Hindi ko alam kung tatapusin ko na rito, pero mag-break muna tayo before ko i-determine kung tutuloy ko pa to. Okay. Sige. Siya muna kayo. Hello, so, okay. Part 4, the law on copyright, no? Copyright para sa mga composers, ha? Para sa mga katulad ko, o di ba? Isa akong composer din, di ba? Okay, wait lang, wait. Ay, reply lang ako. Okay, so, subukan na nating basahin ito. Copyright, no? Section 71, definitions. For the purpose of this act, the following terms have the following meaning. Author is the natural person who has created the work. Ayan, ha? A collective work, ayan, is a work which has been created by two or more natural persons at the initiative and under the direction of another, with the understanding that it will be disclosed by the latter under his own name, and that contributing natural persons will not be identified. So, collective work, parang iisa lamang yung makikinabang, parang under his own name, pero hindi napapangalanan yung mga tumulong sa kanya makipag-collab, no? Collective work ang tawag doon. Okay. Communication to the public or communicate to the public. Wait lang. Okay, communication to the public or communicate to the public means that the making of a work available to the public by wire-to-wireless means in such a way that members of the public may access these works from a place and time individually chosen by them. Computer is an electronic or similar device having information processing capabilities, and a computer program is a set of instructions expressed in words, codes, schemes, or in any other form which is capable when incorporated in a medium that the computer can read, or causing the computer to perform or achieve a particular task or result. Public lending is the transfer of possession of the original or a copy of a work or sound recording for a limited period for non-profit purposes by an institution, the services of which are available to the public, such as public library or archive. Public performance. Ibig niya daw sabihin, in the case of a work other than an audiovisual work, is the recitation, playing, dancing, acting, or otherwise performing the work, either directly or by means of any device or process. In the case of an audiovisual work, the showing of its images in sequence and the making of the sounds accompanying it audible. And in the case of a sound recording, making the recorded sounds audible at a place or at places where persons outside the normal circle of a family and that family's closest social acquaintances are or can be present, irrespective of whether they are or can be present at the same place and at the same time, or at different places and or at different times, and where the performance can be perceived without the need for communication within the meaning of subsection 171.3. Published works means works which, with the consent of the authors, are made available to the public by wire or wireless means in such a way that members of the public may access these works from a place and time individually chosen by them, provided that availability of such copies has been such as to satisfy the reasonable requirements of the public having regard to the nature of work. So, kunwari ito, nag-end live na ako at na-publish ko na ito para mapanood ng mga hindi nanood sa akin ng live. Pwede kong i-example ito as a published work. Rental is the transfer of the possession of the original or a copy of a work or a sound recording for a limited period of time for profit-making purposes. Reproduction is the making of one or more copies of a work or a sound recording in any matter or form. A work of applied art, yan, ang ibig niya sabihin, is an artistic creation with utilitarian functions or incorporated in a useful article, whether made by hand or produced on an industrial scale. At ang sa huli na kailangan nating i-define, work of the government of the Philippines is a work created by an officer or employee of the Philippine government or any of its subdivisions and instrumentalities, including government-owned or controlled corporations as part of his regularly prescribed official duties. Okay, Chapter 2, Original Works. Literary and artistic works. Okay. Literary and artistic works, hereinafter referred to as works, are original intellectual creations in the literary and artistic domain, protected from the moment of their creation, and shall include in particular, ito yung mga kasali. Letter A, books, pamphlets, articles, and other writings. Letter B, periodicals and newspapers. Letter C, lectures, sermons, addresses, dissertations prepared for oral delivery, whether or not reduced in writing or other material form. Letters. Letter D. Letter E, dramatic or dramatico-musical compositions, choreographic works, or entertainment in dumb shows. Letter F, musical compositions with or without words. Letter G, works of drawing, painting, architecture, sculpture, engraving, lithography, or other works of art. Models or designs for works of art. Letter H, original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design, and other works of applied art. Letter I, illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. Letter J, drawings or plastic works of a scientific or technical character. Letter K, photographic works, including works produced by a process analogous to photography, lantern slides, yan. Letter L, audiovisual works and cinematographic works and works produced by a process analogous to cinematography or any process for making audiovisual recordings. Letter M, pictorial illustrations and advertisements. Letter N, computer programs. And letter O, other literary, scholarly, scientific, and artistic works. Sabi pa rito, works are protected by the sole fact of their creation, irrespective of their mode or form of expression, as well as of their content, quality, and purpose. So the moment na sinulat ko yung isang kanta, kasi ako pa isang manunulat ng kanta, at ako'y manlilikha din, meron na rin ako naisulat na libro ng mga compilation ng aking mga sulatin. yung gawa mo na yun ay protektado from the moment of their creation. Chapter 3, Derivative Works. Okay. The following derivative works shall also be protected, sabi niya, by copyright. Letter A, dramatizations, translations, adaptations, abridgments, arrangements, and other alterations of literary or artistic works. And letter B, collections of literary, scholarly or artistic works and compilations of data and other materials which are original by reason of the selection or coordination or arrangement of their contents. The works referred to in paragraphs A and B of subsection 173.1, yung kakabasa lang natin, shall be protected as new works, provided, however, that such new work shall not affect the force of any subsisting copyright upon the original works employed or any part thereof, or be construed to imply any right to such use of the original works, or to secure or extend copyright in such original works. Section 174, published edition of work. In addition to the right to publish granted by the author, his heirs or assigns, the publisher shall have a copyright consisting merely of the right of reproduction of the typographical arrangement of the published edition of the work. Tungo naman tayo sa Chapter 4, Works Not Protected. Section 175, notwithstanding the provisions of Sections 172 and 173, no protection shall extend under this law to any idea, procedure, system, method, or operation, concept, principle, discovery, or mere data, as such even if they are expressed, explained, illustrated, or embodied in a work. News of the day and other miscellaneous facts having the character of mere items of press information, or any official text of a legislative, administrative, or legal nature, as well as any official translation thereof. So siguro pwede kong may example nito yung unprotected subject matter, kunwari balita, di ba? Ang balita ay pwede mong i-share, di ba? Sinishare natin, kunwari may news, ang isang mainstream media, nag-post sila, share natin, yun ay unprotected work. Di ba? Sapagkat balita yun na nilagay dito, hindi siya kasali Okay, hindi extended ang protection sa kanya. News of the day, sabi niya. Ito siguro, itong ginagawa ko, pwede ko rin sabihin unprotected kasi dinerive ko lang to derived from yung mga nababasa natin na legal ko, mga batas which is available to the public by internet, binabasa ko lang siya. At yung iba, pag kaya kong ipaliwanag sa Tagalog, pinaliliwanag natin, di ba? Section 176, Works of the Government. No copyright shall subsist in any work of the government of the Philippines. However, prior approval of the government agency or office wherein the work is created shall be necessary for exploitation of such work for profit. Kung pagkakakitaan mo nga naman yung work ng gobyerno, syempre kailangan muna ng approval nila. Such agency or office may, among other things, impose as a condition the payment of royalties. Kahit na hindi sila protektado ng copyright, pwede silang mag-impose ng royalties kasi pagkakakitaan mo saka gobyerno sila di ba? No prior approval or condition shall be required for the use of any purpose of statutes, rules, regulations, speeches, lectures, sermons. No prior approval daw dito sa mga statutes. Ito yung ginagawa ko ngayon, nagbabasa tayo ng batas. Rules and regulations, speeches, lectures, sermons, addresses, and dissertations pronounced, read, or rendered in courts of justice, before administrative agencies, in deliberative assemblies, and in meetings of public character. So, hindi ko na kailangan magpaalam sa Kongreso, sa mga gumawa ng mga batas na ito, di ba? Actually, nakakatulong pa ako sa gobyerno kasi natutulungan ko silang ipakalat yung ating Philippine laws, di ba? The author of speeches, lectures, sermons, addresses, and dissertations mentioned in the preceding paragraph shall have the exclusive right of making a collection of his works. Notwithstanding the foregoing provisions, the government is not precluded from receiving and holding copyrights transferred to it by assignment, bequest, or otherwise. So, pwede silang tumanggap pwedeng mag-transfer ka sa gobyerno ng assignment, ng copyright through assignment, bequest, o iba pa. Nor shall publication or republication by the government in a public document of any work in which copyright is subsisting be taken to cause any abridgment or annulment of the copyright or to authorize any use or appropriation of such work without the consent of the copyright owners. Doon naman tayo sa Chapter 5, Copyright or Economic Rights. Section 177. Copy or economic rights subject to the provisions... Teka lang, nagtuloy-tuloy ako eh. Subject to the provisions of Chapter 8, copyright or economic rights shall consist of the exclusive right to carry out, authorize, or prevent the following acts. Okay? Reproduction of the work or substantial portion of the work, dramatization, translation, adaptation, abridgment, arrangement, or other transformation of the work, the first public distribution of the original and each copy of the work by sale or other forms of transfer of ownership, rental of the original or a copy of an audiovisual or cinematographic work, a work embodied in a sound recording, a computer program, a compilation of data and other materials or a musical work in graphic form, irrespective of the ownership of the original or the copy which is the subject of the rental, public display of the original or a copy of the work, public performance of the work, and other communication to the public of the work. Okay, Chapter 6, Ownership of Copyright. Ayan. Section 178, Rules on Copyright Ownership. Copyright ownership shall be governed by the following rules. Number 1, subject to the provisions of this section, in case of original literary and artistic works, copyright shall belong to the author of the work. Number 2, in the case of works of joint authorship, the co-authors shall be the original owners of the copyright, and in the absence of agreement, their rights shall be governed by the rules on co-ownership. If, however, a work of joint authorship consists of parts that can be used separately and the author of each part can be identified, the author of each part shall be the original owner of the copyright in the part that he has created. Number 3, in case of work created by an author during and in course of his employment, the copyright shall belong to, letter A, the employee, if the creation of the object of copyright is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer, and letter B, the employer, if the work is result of the performance of his regularly assigned duties, unless there is an agreement, express or implied, to the contrary. So kung kunwari, ikaw, nagtatrabaho ka sa isang opisina, tapos nakagawa ka ng aklat sa pagtatrabaho mo, that is not part of your regular duty, so sa employee yun, sa'yo yun. Sa employer naman, ang copyright kapag ang trabaho mo kunwari ay maggawa talaga ng aklat o mag-proofread or editor ka, at sa trabaho mong yun, nakagawa ka ng isang aklat o ng mga sulatin, sa employer yun kasi it is the result of the performance of your regularly assigned duties. In the case of a work commissioned by a person other than an employer of the author and who pays for it, and the work is made in pursuance of the commission, the person who so commissioned the work shall have ownership of work, but the copyright thereto shall remain with the creator. Yan, tandaan natin. Unless there is a written stipulation to the contrary. Pag walang stipulation, yung copyright shall always remain with the creator. In case of audiovisual work, the copyright shall belong to the producer, the author of the scenario, the composer of the music, the film director, and the author of the work so adapted. However, subject to the contrary or other stipulations among the creators, the producers shall exercise the copyright to an extent required for the exhibition of the work in any manner, except for the right to collect performing license fees for the performance of musical compositions with or without words, which are incorporated into the work. And number 6, in respect of letters, the copyright shall belong to the writer. Okay? Subject to the provisions of Article 723 of the Civil Code. So, yung writer, yung creator, sa kanila talaga yan, unless there is a stipulation to the contrary. Section 179, anonymous and pseudonymous works. For purposes of this act, the publishers shall be deemed to represent the authors of articles and other writings published without the names of the authors, or articles and other writings published without the names of the authors or others, or under pseudonyms. Okay? Pwedeng gawin yan ng publishers unless the contrary appears or the pseudonyms or adopted name leaves no doubt as to the author's identity, or if the author of the anonymous works discloses his identity. So ako, pwede ko nang sabihin yung mga names ko, Lolo Ray, pseudonym ko, Lolo Ray, Wes, at kung ano-ano pa. Okay, interesting ito. Babalikan pa natin. Marami-rami pa tayong babasahin, no? Papahinga lang tayo saglit. Okay, so wow, nakaka 2 hours na tayo ha. Nandito na tayo sa chapter 7, transfer or assignment of copyright. Ito yung rights of assignee o yung pinag-assignan, yung pinag-transferan ng copyright rights. Number 1, the copyright may be assigned in whole or in part within the scope of the assignment. The assignee is entitled to all the rights and remedies which the assigner had with respect to the copyright. Number 2, the copyright is not deemed assigned inter vivos in whole or in part unless there is a written indication of such intention. The submission of a literary, photographic, or artistic work to a newspaper, magazine, or periodical for publication shall constitute only a license to make a single publication unless a greater right is expressly granted. If two or more persons jointly own a copyright or any part thereof, neither of the owners shall be entitled to grant licenses without the prior written consent of the other owner or owners. Section 181, Copyright and Material Object. The copyright is distinct from the property in the material object subject to it. Consequently, the transfer or assignment of the copyright shall not itself constitute a transfer of the material object, nor shall a transfer or assignment of the sole copy or of one or several copies of the work imply transfer or assignment of the copyright. Sabi niya, iba daw yung copyright kaysa dun sa mismong material object to it. Yung transfer daw or assignment ng copyright ay hindi ibig sabihin na inilipat mo na yung material object. Yung transfer naman ng material object, hindi naman ibig sabihin inilipat mo na yung copyright. Section 182, Filing of Assignment of License. An assignment or exclusive license may be filed in duplicate with the National Library upon payment of the prescribed fee for registration in books and records kept for the purpose. Upon recording, a copy of the instrument shall be returned to the sender with a notation of the fact of record. Notice of the record shall be published in the IPO Gazette. Section 183, Designation of Society. The copyright owners or their heirs may designate a society of artists, writers, or composers to enforce their economic rights and moral rights on their behalf. Okay? Chapter 8, Limitations on Copyright. Section 184. Notwithstanding the provisions of Chapter 5, the following acts shall not constitute infringement of copyright. Ito yung mga hindi naman ibig sabihin copyright infringement na. Letter A, the recitation or performance of a work once it has been lawfully made accessible to the public, if done privately and free of charge, or if made strictly for a charitable or religious institution or society. So parang yung ginagawa ko ngayon, binabasa ko yung mga batas na isinapubliko na yan. Ang mga batas, kada napiprint yan, nilalagay yan sa official gazette o yung publication ng pamahalaan para i-disseminate o ipakalat sa lahat. So tinutulungan ko lang sila, ang gobyerno na i-disseminate. So hindi daw copyright infringement itong ginagawa kong pagbabasa ng batas. Letter B, the making of quotations from a published work, if they are compatible with fair use only to the extent justified for the purpose, including quotations from newspaper articles and periodicals in the form of press summaries, provided that the source and the name of the author, if appearing on the work, are mentioned. Letter C, the reproduction or communication to the public by mass media of articles on current political, social, economic, scientific, or religious topic, lectures, addresses, and other works of the same nature which are delivered in public, if such use is for information purposes and has not been expressly reserved, provided that the source is clearly indicated. Letter D, the reproduction and communication to the public of literary, scientific, or artistic works as part of reports of current events by means of photography, cinematography, or broadcasting to the extent necessary for the purpose. Letter E, the inclusion of a work in a publication, broadcast, or other communication to the public, sound recording or film, if such inclusion is made by way of illustration for teaching purposes and is compatible with fair use. provided that the source of the same of the author, if appearing in the work, are mentioned. Letter F. The recording made in schools, universities, or educational institutions of a work included in a broadcast for the use of such schools, universities, or educational institutions, provided that such recording must be deleted within a reasonable period after they were first broadcast. Provided further that such recording may not be made from audiovisual works which are part of the general cinema repertoire of feature films, except for brief excerpts of the work. Letter G. The making of ephemeral recordings by a broadcasting organization by means of its own facilities and for use in its own broadcasts. Letter H. The use made of a work by or under the direction or control of the government, by the National Library, or by educational, scientific, or professional institutions where such use is in the public interest and is compatible with fair use. Letter I. The public performance or the communication to the public of a work in a place where no admission fee is charged in respect of such public performance or communication by a club or institution for charitable or educational purpose only, whose aim is not profit making, subject to such other limitations as may be provided in the regulations. Letter J. Public display of the original or a copy of the work not made by means of a film, slide, television image, or otherwise on screen or by means of any other device or process, provided that either the work has been published or that original or the copy displayed has been sold, given away, or otherwise transferred to another person by the author or his successor in title. And letter K. Any use made of a work for the purpose of any judicial proceedings or for the giving of professional advice by a legal practitioner. Sinasabi rin sa Section 184, the provisions of this section shall be interpreted in such a way as to allow the work to be used in a manner which does not conflict with the normal exploitation of the work and does not unreasonably prejudice the right holder's legitimate interest. Section 185, fair use of a copyrighted work. Ito yung lagi nating nakikita. Actually, may share ko lang sa inyo nung nasa radio station ako. Pagka nagpo-programa kami, mga kwento-kwentuhan, payo sa pag-ibig, lagi kaming nagkakaproblema pag gagamit kami ng songs, tapos i-mute ng Facebook Live or mute ng YouTube yung portions na nagpapatugtog kami ng song ng iba kahit pa ilagay namin na no copyright infringement intended. Okay, Section 185, fair use of a copyright work. The fair use of a copyrighted work for criticism, comment, news, reporting, teaching, including multiple copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright. Decompilation, which is understood here to be the reproduction of the code and translation of the forms of the computer program to achieve the interoperability of an independently created computer program with other programs, may also constitute fair use. In determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include letter A, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Letter B, the nature of the copyrighted work. Letter C, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And letter D, the effect of the use upon the potential market for or value of the copyrighted work. Sabi pa rito, the fact that a work is unpublished shall not by itself bar a finding of fair use if such finding is made upon consideration of all the above purpose. So kahit na hindi nakapublish yung gawa, hindi ibig sabihin ito ay haharangan nito yung nasuriin kung ito ba ay ginamit sa fair use o hindi. Section 186, work of architecture. Copyright in a work of architecture shall include the right to control the erection of any building which reproduces the whole or a substantial part of the work, either in its original form or in any form recognizably derived from the original, provided that the copyright in any such work shall not include The right to control the reconstruction or rehabilitation in the same style as the original of a building to which the copyright relates. Section 187, reproduction of published work. Notwithstanding the provisions of Section 177 and subject to the provisions of subsection 187.2, the private reproduction of a published work in a single copy, where the reproduction is made by a natural person exclusively for research and private study, shall be permitted without the authorization of the owner of copyright in the work. Sabi pa sa subsection 2, subsection 187.2, the permission granted under subsection 187.1 shall not extend to the reproduction of letter A, work of architecture in form of building or other construction, letter B, an entire book or a substantial passage thereof, or of a musical work in which graphics formed by reprographic means, letter C, a compilation of data and other materials, letter D, a computer program, except as provided in section 189, and letter E, any work in cases where reproduction would unreasonably conflict with the normal exploitation of the work or would otherwise unreasonably prejudice the legitimate interests of the author. Okay. Section 188 na tayo. Malayo-layo pa tayo sa katotohanan. Okay. Pero subukan natin basahin na rin. Section 188. Reprographic reproduction by libraries. Okay. 188.1, notwithstanding the provisions of subsection 177.6, any library or archive whose activities are not for profit may, without authorization of the author or of copyright owner, make a single copy of the work by reprographic reproduction. Pwede raw siya. Okay. Where the work, by reason of its fragile character or rarity, cannot be lent to user in its original form, sabi. Where the works are isolated articles contained in composite works or brief portions of other published works, and the reproduction is necessary to supply them. Yan, mga ganyan. Mga ganyang kadahilanan. Pwede rin yung mga reproduction through a computer program. Backup copy raw, hindi pwede. The use of computer program in conjunction with a computer for the purpose, pwede yan. Archival purposes and for the replacement of the lawfully owned copy of the computer program, pwede yun. Hindi siya copyright infringement. Sabi pa rito, no copy or adaptation mentioned in this section shall be used for any purpose other than the ones determined in this section. Doon na tayo sa section 190, importation for personal purposes. Sabi rito, the importation of a copy of a work by an individual for his personal purposes shall be permitted without the authorization of the author under the following circumstances. Letter A, when copies of the work are not available in Philippines. Okay. Sabi, tapos not more than one copy lang at the time of the importation, and the importation is by authority and for the use of the Philippine government. O di naman, the importation consisting of not more than 3 copies or likeness in any one invoice is not for sale. Okay. Or not for use for religious, charitable, or for be used only for religious, charitable, educational society at hindi for commercial uses. And letter B, when such copies form part of libraries and personal baggage belonging to persons or families arriving from foreign countries and are not intended for sale. Okay. Doon na tayo sa chapter 10, deposit and notice, section 191. After the first public dissemination of performance by authority of the copyright owner of a work, falling under subsections 172.1, 172.2, and 172.3 of this Act, thereof for the purpose of completing the records of the National Library in the Supreme Court Library, within 3 weeks be registered and deposited with it by personal delivery or by registered mail 2 complete copies or reproductions of the work in such form as the directors of said libraries may prescribe. So magkakaroon yun ng certificate of deposit that shall be issued by the director of the library, no? Section 192, notice of copyright. Each copy or offered for sale may contain a notice bearing the name of the copyright owner and the year of its publication, and in copies produced after the creator's death, the year of such death. Magtungo tayo sa Chapter 10, Moral Rights. Section 193, the author of a work shall, independently of the economic rights in Section 177 or the grant of an assignment or license with respect to such right, meron siyang karapatan to require that the authorship of the works be attributed to him. In particular, syempre siya yung gumawa to make any alterations of his work prior to or to withhold it from publication, to object to any distortion, mutilation, or other modification, to restrain the use of his name with respect to any work not of his own creation or in a distorted version of his work. Tungo tayo Section 194, Breach of Contract. An author cannot be compelled o hindi mo siya pwedeng pilitin to perform his contract to create a work or for the publication of his work already in existence. However, he may be held liable for damages for breach of such contract. Section 197, Waiver of Moral Rights. An author may waive his rights mentioned in Section 193 by a written instrument, but no such waiver shall be valid where its effects is to permit another. Sabi pa rito, to use the name of the author, the title of his work, or otherwise to make use of his reputation with respect to any version or adaptation of his work. Okay? Which, because of alterations therein, would substantially tend to injure the literary or artistic reputation of another author, or to use the name of the author with respect to a work he did not create. Section 196, Contribution to Collective Work. When an author contributes to a collective work, his right to have his contribution attributed to him is deemed waived unless he expressly reserves it. Section 197, Editing, Arranging, and Adaptation of Work. In the absence of a contrary stipulation at the time an author licenses or permits another to use his work, the necessary editing, arranging, or adaptation of such work for publication, broadcast, use in a motion picture, etc., shall not be deemed to contravene the author's rights secured by this chapter. Nor shall complete destruction of a work unconditionally transferred by the author be deemed to violate such rights. Section 198, Term of Moral Rights. Sabi rito, the rights of an author under this chapter shall last during the lifetime of the author and for 50 years after his death, and shall not be assignable or subject to license. The person or persons to be charged with the posthumous enforcement of these rights shall be named in writing to be filed with the National Library. In default of such person or persons, such enforcement shall devolve upon either the author's heirs, and in default of the heirs, the director of the National Library. National Library, okay. For purposes of this section, person shall mean any individual, partnership, corporation, association, or society. The director of the National Library may prescribe reasonable fees to be charged for his services in the application of provisions of this section. Section 199, Enforcement Remedies. Violation of any of the rights conferred by this chapter shall entitle those charged with their enforcement to the same rights and remedies available to a copyright owner. In addition, damages which may be availed of under the Civil Code may also be recovered. Any damage recovered after the creator's death shall be held in trust for and remitted to his heirs, and in default of the heirs, shall belong to the government. Kung wala siyang heirs, sa government. Okay. Chapter 11, Rights to Proceeds in Subsequent Transfers. Section 200, Sale or Lease of Work. In every sale or lease of an original work of painting or sculpture, or of the original manuscript of a writer or composer, subsequent to the first disposition thereof by the author or his heirs shall have an inalienable right to participate in the gross proceeds of the sale or lease to the extent of 5%. Okay? Laging may inalienable right to participate in the gross proceeds of the sale or lease to the extent of 5% yung author or his heirs. This right shall exist during the lifetime of the author and for 50 years after his death. Section 201, Works not covered. Okay, the provisions of the chapter shall not apply to prints, etchings, engravings, works of applied art, or works of similar kind wherein the author primarily derives gain from the proceeds of the reproductions. Pero maano ko lang, no? So, yung author, lifetime niya yan, siyang may karapatan to 5%, no? Ng gross proceeds of sale or lease na kahit na ano na may kinalaman sa gawa niya, and for 50 years after his death. Okay, so ibig sabihin ba hindi naabutan ng mga apo niya, no? 50 years after his death, yung heirs niya na lang makikinabang doon. So pag lumagpas yung 50 years after his death, wala na, parang expired na, no? Chapter 7, Rights of Performers, Producers of Sounds, Recordings, and Broadcasting Organizations. Definition of terms muna tayo. Section 202, performers are actors, singers, musicians, dancers, and other persons who act, sing, declaim, play in, interpret, or otherwise perform literary and artistic work. Sound recording means the fixation of the sounds of a performance or of other sounds or representation of sound other than in the form of a fixation incorporated in a cinematographic or other audiovisual work. An audiovisual work or fixation is a work that consists of a series of related images which impart the impression of motion with or without accompanying sounds susceptible of being made visible and were accompanied by sounds susceptible of being made audible. Fixation means the embodiment of sounds or of the representations thereof from which they can be perceived, reproduced, or communicated through a device. Producer of a sound recording means the person or the legal entity who or which takes the initiative and has the responsibility for the first fixation of the sounds of a performance or other sounds or the representation of sounds. Publication of a fixed performance or a sound recording means the offering of copies to the fixed performance or the sound recording to the public with the consent of the right holder, provided that copies are offered to the public in reasonable quality. Broadcasting means the transmission by wireless means for the public reception of sounds or of images or of representations thereof. So this is broadcasting, no? Broadcasting organization shall include a natural person or a juridical entity, kunwari GMA7 Corporation, duly authorized to engage in broadcasting. Communication to the public of a performance or a sound recording means the transmission to the public by any medium otherwise than by broadcasting of sounds of a performance or the representations of sounds fixed in a sound recording. Okay. Tungo tayo sa Section 203, Scope of Performers' Rights. As regards their performances, the right of authorizing, letter A, the broadcasting and other communication to the public of their performance, and letter B, the fixation of their unfixed performance. The right of authorizing the direct or indirect reproduction of their performances fixed in sound recordings in any manner or form. Okay? So, ang example na lang dyan is, kunwari si Sarah Geronimo, nung tuwing kumakanta siya dati sa ASAP. So, yung broadcasting and other communication to the public ng kanilang performance, yan, right nila yan. Okay? Or right pala ng ASAP yun, ano? Ewan ko na, naguluhan ako. Pero yun daw ang right ng performers. Okay, magtungo tayo Section 204, Moral Rights of Performers. Sabi rito, independently of a performer's economic rights, the performer shall, as regards his live oral performance or performances fixed in sound recordings, have the right to claim to be identified as the performer of his performances. Karapatan niyang matukoy. Ladies and gentlemen, Sarah Geronimo. Or ladies and gentlemen, Lolo Ray. Ayan, di ba? Ako yun. Okay, the rights granted to a performer in accordance with subsection 203.1 shall be maintained and exercised 50 years after his death. Yung keyword pala yun, no? 50 years after his death by his heirs. In default of heirs, the government where protection is claimed. Section 205, limitation on right. subject to the provisions of sections 206. Once the performer has authorized the broadcasting or fixation of his performance, the provisions of sections 203 shall have no further application. Section 206, unless otherwise provided in the contract, in every communication to the public or broadcast of a performance subsequent to the first communication or broadcast thereof by the broadcasting organization, yung performer daw shall be entitled to an additional remuneration equivalent to at least 5% of the original compensation he or she received for the first communication on broadcast. Section 207, Contract Terms. Nothing in this chapter shall be construed to deprive performers of the right to agree by contracts or on terms and conditions more favorable for them in respect of any use of their performance. Pero ang kadalasang favorable yan sa network. Laging kawawa, lalo na sa Amerika, yung mga performers when it comes to their performance. Chapter 8, Producers of Sound Recordings. Section 208, sabi rito, producers of sound recordings shall enjoy the following exclusive rights. Sabi, right to authorize the direct or indirect reproduction of their sound recordings, right to authorize the first public distribution of the original and copies of their sound recordings, the right to authorize the commercial rental of the public of the original and copies of their sound recordings even after distribution by them, by or pursuant to authorization by the producer. Section 209, Communication to the Public. If a sound recording published for commercial purposes or a reproduction of such sound recording is used directly for broadcasting or for other communication to the public, or is publicly performed with the intention of making and enhancing profit, a single equitable remuneration for the performer or performers and the producer of the sound recording shall be paid by the user to both the performers and the producer who, in the absence of any agreement, shall share equally. So kung anwari ako, gusto kong gamitin yung mga iba't ibang music na copyrighted dito sa YouTube habang ako ay nagbo-broadcast, kailangan bayaran ko muna sila. O meron ngang although meron ngang limitation dito na sharing. Kunwari, kinover ko yung song, nilagay ko dito sa YouTube. It's either hindi siya monetized o di naman kaya sharing kami. An example nun is yung cover ko ng kanta ni John Mayer. Laging sharing kami. So gusto niya yon, matalino siya. Baka sakaling kumita ako, kikita rin siya. Siya yung original eh. So ganun po. Okay. Sana tayo? Okay. Okay, so basahin na lang natin tong infringement, no? Sabi rito, Section 216, very important to. Nilaktawan na natin yung iba na hindi naman masyado important. Masyado na tayo mahaba. Remedies for infringement, sabi dito, any person infringing a right protected under this law shall be liable, letter A, to an injunction restraining such infringement. Court order po yan, nasasabihin sa iyo na, hoy, tigilan mo yan. Letter B, pay to the copyright proprietor or his assigns or heirs such actual damages including legal costs and other expenses as he may have incurred, no? Letter C, deliver under oath for impounding during the pendency of the action upon such terms and conditions as the court may prescribe. So pwedeng kunin ng court yung mga articles o yung mga equipments mo na nagko-cause ng infringement. Letter D, deliver under oath for destruction, sisirain na yan, without any compensation, all infringing copies or devices. Example dyan, yung mga pirated DVDs, ganyan. Letter E, such other terms and conditions including the payment of moral and exemplary damages which the court may deem proper, no? Okay, meron din siya mga criminal. So ito in an infringement action, the court shall also have the power to order the seizure and impounding of any article which may serve as evidence in the court proceedings. Meron din siyang criminal penalties, no? Meron mga special laws kasi rin na dito, no? Like yung sa Anti-Piracy Act siguro. special law yun na nagsusupplement o yung nag-aano when it comes to DVDs. So, huwag na nating basahin tong pero definitely gusto ko lang i-share sa inyo, mabigat ang criminal case dito, no? Mabigat ang criminal penalties. Sabi rito, any person infringing any rights secured by provisions of Part 4 of this Act or aiding or abetting such infringement shall be guilty of a crime punishable by imprisonment of 1 year to 3 years plus a fine ranging from 50 to 150,000 pesos. Iba-iba, imprisonment of 3 years, iba-iba, depende sa iyong ginawa, no? Section 218, in an action under this chapter, an affidavit made before a notary public by or on behalf of the owner of the copyright in any work or other subject matter and stating that at the time specified therein copyright subsisted in the work or other subject matter, letter B, he or the person named therein is the owner of the copyright, and letter C, the copy of the work or other subject matter annexed thereto is a true copy thereof. Isasubmit siyang lahat, sabi, sa proceedings for an offense under this chapter and shall be prima facie proof of the matters therein stated until the contrary is proved. Okay? Nako, no? Okay, so sige. Ito pa, Institution of Action, Section 225. Mahalaga kasi ito Jurisdiction. Without prejudice to the provisions of subsections 7.1c, actions under this act shall be cognizable by the courts with appropriate jurisdiction under existing law. Malamang RTC, Regional Trial Courts. Section 226, no damages may be recovered under this act after 4 years from the time the cause of action arose. So, pwede nating sabihin 4 years ang prescription period ng mga reklamo natin sa copyright infringement. Okay? Basahin natin yung iba na lang, yung mga mahalaga like in all inter-parties proceedings in office under this act, the equitable principles of laches, estoppel, and acquiescence where applicable may be considered and applied. Reverse reciprocity of foreign laws. So any condition, restriction, limitation, diminution, requirement, penalty, or any similar burden imposed by the law of a foreign country on a Philippine national seeking protection of intellectual property rights in that country shall reciprocally be enforceable upon nationals of said country within Philippine jurisdiction. Okay, basahin natin to Section 232, Appeals. Appeals from decisions of regular court shall be governed by rules of court. Unless restrained by a higher court, the judgment of the trial court shall be executory even pending appeal under such terms and conditions as the court may prescribe. Section 232 yun, mahalaga ito. Okay. So, okay na. So, natapos na tayo. Natapos na natin. Nabasa natin. Halos buo. No? May mga nilaktawan ako dito bandang huli. Konting-konti na lang. Mga hindi na mahalaga sa kaalaman natin. So, sana nag-enjoy kayo no, sa panonood na, sa pagbabasa natin ng Intellectual Property Code. Diba? Under pa rin yan ng commercial law. So, next time, sana samahan nyo pa rin ako sa aking pagbabasa. At subukan nating ipaliwanag at unawain ng batas in layman's term. So pray muna tayo. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. Lord, thank you at hinayaan mo ako magbasa. Almost 3 hours na ako nagbabasa. Sana okay naman ang aking kalusugan. Maraming salamat. In Jesus' name, amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. So good night sa inyong lahat, and God bless.